Okay, so here's the situation. You do a dispute through the credit bureaus. They notify some of the data furnishers, the people that provide or furnish information to the credit bureau. And then they let you know either they're removing it, they're keeping it, they're updating it, the information. And then you sue the data furnisher. What's the statute of limitations? How long do you have to sue? What starts it? What's the trigger for the clock starting to tick? And how do you know if you filed it within time? So that's what we're going to cover in this opinion. This is the Pritchett case from Northern District of Alabama. A friend of mine, Maurice Scott, very good consumer lawyer, has this case. And so I thought this would be a good one to go over. So let's, again, take a step back, kind of get our bearings, and then we'll jump into this opinion. So there's two ways you can do a dispute involving a data furnisher. You can reach out directly to the data furnisher under the Fair Credit Reporting Act. And you certainly have that option. They have requirements about making sure information is accurate and complete. Unfortunately, you can't sue them over that. The other option is you go to the credit bureau. So Equifax, Experian, TransUnion, etc. You go to them and say, hey, there's something wrong with this account. The information provided by this data furnisher, this creditor or collector, whoever it may be, is inaccurate, it's incomplete. I want you to investigate. And then the credit bureau notifies the furnisher. Now the furnisher has an obligation to investigate, to make it accurate, make it complete. And if they do that investigation negligently, you can sue them. But when does the clock start running? When does the 2-year statute of limitation begin? That's what we'll cover in this case. So let's look at it very quickly here. So the allegation is Westlake Services furnished inaccurate information. It said a past due car loan was under her name when it was not. All right. So on April 15, and some of these dates are important, so we'll kind of highlight these. April 15, letters were mailed. And then information is forwarded to Westlake, and then Experian concluded the investigation on May 23. And so on that same date, Experian sends a letter or a notification to the plaintiff, the one suing, the consumer here. So the dispute was made April 15. Experian concludes its investigation on May 23. And so there's still false information. And so then they ended up suing. Okay, and that was sued in Circuit Court, Jefferson County. And then the defendant removed or transferred that case from the Circuit Court, the state court, to the federal district court, which is very common that this happens. So there's count one. So negligent noncompliance with 1681 S2B. Now 1681 S2A is when you make a direct dispute to the data furnisher. Unfortunately, you can't sue over that under the Fair Credit Reporting Act. And then count two is willful noncompliance. So count one is, hey, Westlake, you were negligent, you were careless. Count two is you were intentionally or recklessly, you violated law. And then we have count three, which involves 1681B, and then a willful part of that. All right, so these last two sections or counts, causes of action, relate to obtaining a credit report, and the plaintiff voluntarily dismissed those. Okay, so we're just focused on the negligent and reckless investigation by Westlake, and were those claims filed within the statute of limitation. So here's the standard for a complaint. You must include enough facts to raise a right to relief above the speculative level. So you can't just file a lawsuit and say, well, you know, if you sort of look at it a certain way, it's possible that this will do it. It's got to be a little bit more than that. So what the court says is it has to be plausible. Now, some of these words sort of, the eye of the beholder type thing, okay? But here, facial plausibility when the plaintiff pleads factual content allows the court to draw the reasonable inference that the defendant's liable. And so it's not a probability requirement, but it's more than a sheer possibility, okay? So in a 12b6 motion to dismiss, and the rule refers to Federal Rule of Civil Procedure 12b6, you look at the allegations in the light most favorable to the non-moving party. So if you, as the court, can see, well, there's different ways to look at this, you should give the benefit of the doubt to the party that is not moving to dismiss the case. So that would be the plaintiff, the consumer. And then the court should eliminate any allegations that are merely legal conclusions, and where there are well-pleaded factual allegations, assume their veracity, their truthfulness, their accuracy, and then determine whether those well-pled factual allegations, again, interpreted in the light most favorable to the consumer, because the consumer's not trying to throw the case out, whether they plausibly give rise to entitlement to relief. Okay, so let's look. Why do we have the Fair Credit Reporting Act, the FCRA? Protect consumers from unfair reporting methods while also ensuring the credit system would retain the accuracy required by the banking system to efficiently allocate credit. So there's two aspects here. One is we want to make sure that in this economy that those who are using a credit report, and that's what they're called, users, that there's information that is accurate there. Okay, and I would also add that is complete. Okay, so if you're going to furnish something, information, if you're going to report information, make sure it's accurate, make sure it's complete. And also to protect the consumer, to make sure this is not unfair. So we have consumer reporting agencies, also called credit bureaus. So that's going to be like Equifax, Experian, TransUnion. And then furnishers. So those are organizations. It could be a auto loan, it could be a mortgage, it could be a credit card, it could be a debt collector that provide or furnish information to the reporting agencies. Now there's a third category known as users. Those are people who obtain or use credit reports to make decisions. Maybe, do I give you this job? Do I give you this promotion? Do I give you insurance, and how much? Do I give you a loan? What's the interest rate? So really those three categories of companies, we're only focused on two of them here. The consumer reporting agencies, and this motion is not about, it's not been filed by a credit bureau, but you're going to see Experian plays a role in this. And the furnishers, the data furnishers who provide or furnish information. All right, so the FCRA imposes a duty on furnishers not to furnish information to the reporting agencies if they know or have reasonable cause to believe that the information is inaccurate. And then the consumer can dispute the accuracy, either number one, directly with the furnisher, but again, no right to sue under the Fair Credit Reporting Act for that, or indirectly with a credit reporting agency. So again, Equifax, Experian, TransUnion. Once a furnisher receives an indirect dispute from the credit bureau, they must conduct a reasonable information to the information's accuracy. So what is the defendant, this Westlake, this furnisher, what are they arguing? They're saying, hey, counts 1 and 2 are barred by a 2-year statute of limitation. Now, what did the allegations say? Because we have to look at the allegations. Remember the plausibility of those allegations. It said discovered allegedly inaccurate information around February 26 of 22. Well, if that's the test, then you have to file by February 26 of 2024. But that's not the test. Complaint further alleges mailed dispute letters, remember, April 15. And then it was forwarded to Westlake, and then Experian concluded investigation around May 23. And then forwarded a copy on about that same date. Consumer must bring an FCRA violation within 2 years after the discovery. Now, there's another provision that says you can do it within 5 years after the date on which a violation that is a basis for such liability occurs. Okay, but it's not really the subject here. We're talking about when you discover it. That 5 years is really talking about like you never discovered it. But here, they discovered it. All right, so 2 years after discovery. So it's the failure to conduct a reasonable investigation. And then in the Milgram case, the 11th Circuit highlighted the violation that triggers liability isn't the dispute. Okay, so let's back up to here. All right, so they discovered inaccurate information February 26, 2022. That's not the trigger. It's not even the trigger when you mail the letter here, April 15. All right. It isn't the dispute, it's the unreasonable investigation. Plaintiff discovered this alleged violation on or around May 23rd. And then they filed suit on May 7th of 2024, so that's within the 2 years. So this is timely. But here's the critical part. It's not merely discovering that Westlake supposedly provided inaccurate information, because you can't sue just because you find inaccurate information. You can't sue a furnisher for that. Remember, you have to do a dispute through a credit bureau who then notifies the furnisher. That's the only time you can sue, but it's not that dispute itself, it's the lousy investigation. Well, when do you know that there's been a lousy investigation? It would be impossible to know until the credit bureau tells you that, hey, we are keeping this information, or enough time has gone by that you say, you know what, I didn't hear back from Experian or Equifax or TransUnion, but the time period has expired. They obviously are not correcting this or deleting it, so therefore now I know I can sue. It's the knowing you can sue because you know there's a violation. All right, so let's look at the defendant's arguments here. All right, so we've got 2 years after the day of discovery by the plaintiff. The reasonable meaning of discovery by plaintiff is that the plaintiff has notice of the violation. So let's think of sort of a weird scenario where I'm going to use different dates here. So you notice something is wrong on January 1st, you dispute it on January 1st, and on January 2nd, this would be crazy, but the credit bureau tells you, you know what, we're not fixing that. And then 6 weeks later, you get something in the mail. And then you sue, 1 year, 11 months, and 29 days after you received something in the mail. Well, if you knew about it more than 2 years before you filed suit, then you can't sue. That would be too late to sue. Okay. So the point that Judge Proctor is making here is that when did you know about the violation? Plaintiff's discovery on or around May 23rd is enough to trigger the 2-year statute of limitation. Plaintiff correctly highlights, although the defendant did not cite any case law that agreed with its interpretation, several sister circuit courts, so those would be other circuit courts. We're in the 11th Circuit, that might be the 7th Circuit, or here the 9th Circuit, the 4th Circuit, that indicate the date that triggers statute of limitations, date on which plaintiff discovers that an investigation was unreasonable. That's the only way you can possibly interpret this, okay? You have to have notice that the investigation was unreasonable to then be able to sue. So here's the 9th Circuit describing timeliness as connected with the furnisher's duty to investigate. Here's the 4th Circuit. Statute precisely requires 30-day period of investigation have expired for the furnisher to have breached any duty which would give rise to the private right of action. So the point is, when you do a dispute and the credit bureau gets it, the furnisher can't come back and say, well, you should have sued us on day one. Well, the credit bureau and the furnisher had 30 days to investigate. So, and actually technically there is a scenario where it can be 45, but put that aside. So we'll just call it the 30-day right to investigate. So the point is that until the credit bureau has closed the investigation, now they could do that on day 2 or day 22 or day 30, but whenever they close it, that's like the very first point you could possibly know if they immediately notified you. Of course, a lot of times they're mailing you a copy, so it's going to be a few more days. It's always safest to go by the date of what's called the results of investigation by the credit bureau. Okay, and that's what happened here. They're saying, well, we couldn't have known about it till May 23rd because that's when Experian mailed us the copy, and we filed before May 23rd of 2024. So they're good. All right, they're also persuasive in circuit, so that would be within the 11th Circuit district court opinion. So remember, circuit court is the appellate court, and then above all the circuit courts would be the Supreme Court. What can get confusing is state courts are often called, the trial courts are often called circuit courts. That's how it is in Alabama. So you just have to sort of keep in mind there's a federal naming convention and then state. So let's just stick with the federal. You have Supreme Court at the top, and then you have all these circuit courts below that. And then the 11th Circuit has Alabama, Georgia, and Florida district courts. And so here the judge is saying, here's Dorsey versus TransUnion Northern District, May 1st, describing Milgram. That's the case everybody's looking at here. It's holding each time a furnisher fails to conduct a reasonable investigation constitutes a new violation, triggering a new statute of limitation. Coupled with plain reading of the FCRA statutory language. And plain reading just means just take the words at face value. Don't say, well, Congress, they didn't do a good job here. I think here's what they really should have meant. No, just take the plain meaning of it, as well as binding 11th Circuit. Court concludes 2-year statute of limitations under the FCRA is triggered by plaintiff's discovery. As to counts 1 and 2, that violation is the allegedly unreasonable investigation. Discovered this on May 23rd, meaning she must have filed her complaint on or before May 23rd, 2024, which she did. So the plaintiff is successful in this motion. Now, it does not mean the plaintiff, the consumer, has won the case. It means the furnisher, Westlake, has attacked the lawsuit, attacked the complaint in a motion to dismiss, and that was unsuccessful, except for the counts 3 and 4 related to the improper accessing of the credit report. The plaintiff, the consumer, said, you know what, I give up on those claims. Okay, but this is the heart of the case here, counts 1 and 2. So hope this is helpful. I just wanted you to see, and I know I took some time going through this, but I want you to be able to see just in a very sort of logical way why the court looked at the case law, in other words, prior opinions, why the court looked at the statute, looked at the facts of this and said, okay, is it plausible that the plaintiff can win? Well, here, yeah, absolutely plausible. Matter of fact, it's more than plausible. It's almost guaranteed unless some fact comes out saying that, remember the suit was filed, I think, on May 7th. If somehow it came out that the plaintiff knew on May 5th, 2022, that the investigation was closed, well, that might be a different matter here. But here, they wouldn't know until Experian notified them. And so I just want you to see kind of how courts analyze this and look at it. And whenever we're looking at these legal issues, kind of just take a deep breath and let's slow down. Let's look at it very methodically here. Because if we're looking at it too quickly and we ignore things, sort of like in chess, you make a bad move. You're like, oh, why'd I make that bad move? Here, we want to be able to look at it from all angles and say, okay, are we solid on this? Because when we're solid on this and we're dealing with lawyers on the other side who are good lawyers, they can see, kind of to use that analogy of the chessboard, they can see the same chessboard. And if they go, you know what, we're not going to win, they're not going to waste thousands and thousands and thousands of dollars of their clients' money making an attack that is no good. Okay, so the best battle is the one that we can convince the other side not to even engage in. So if we've done our job so that they know they're going to lose, then they're less likely. Now, obviously, they can still file it here. This is really solid what the plaintiff, the consumer, had here. So why this attack was made, I'm not sure. Okay, but anyway, it was unsuccessful. And so I just wanted you to see all that. And as long as you guys like these case discussion videos, then we'll continue to do them. Okay, guys, have a good one. Bye-bye.